Good morning, everyone. My name is Mike Renick. I'm a real estate broker associate. I'm the senior broker, the team lead with Team Renick Real Estate Services. I'm also a broker associate with that great Keller Williams on the Water family, and we're proud to be aligned with those folks. This is Title Time with Mike and Mike. We're one day late. Let me explain what happened yesterday. Every 2 years, real estate agents and brokers are required to be recertified. We spend 2 days in classes learning the latest changes to the code of ethics, the latest changes to the laws and stuff like that. So that's where I've been. And I'm back refreshed with all kinds of great information. But what I'd like to do is we're going to bring Mr. Hankin on, and I'm going to, if I remember how to hit the right buttons here, let me bring him up, and then I'm going to introduce him while he's on the screen this time. There we go. Good morning, Mike.
Good morning, Mike. How are you today?
I'm fine. How are you doing?
Doing great, thanks.
So let me go through the intro, and I know you asked me to pare it down every time, but I love the intro, so I'm going to do the full-fledged thing here. Michael Hankin is, and we're grateful that he's here. He's an attorney with the law firm of Hankin & Hankin. Mr. Hankin practices primarily in the areas of residential and commercial real estate transactions. He is an approved agent for Chicago Title Insurance Company, the Attorney's Title Insurance Fund, and the Old Republic Title Insurance Company. And he's been designated as a board-certified real estate attorney. That's the highest level, of recognition by the Florida Bar. He regularly represents buyers, sellers, and lenders in all aspects of real property transactions. Mr. Hankin grew up in Sarasota. He attended Riverview High School, and then he went on to Emory University, where he received his Bachelor's of Business Administration. And of course, Wake Forest University is where he obtained his Juris Doctorate degree. With that said, welcome, Michael. I'm very pleased and proud to have you here today.
Well, thanks so much for having me again. I'm excited to discuss today's topic, which I'll just dive right into, which is some considerations that buyers or sellers should be aware of when buying in a condominium development or when buying a property in a homeowners association.
May I ask you a question to start us off?
Absolutely.
Could you, for the audience, define, because we use those terms, unfortunately, interchangeably, and they're not the same. Could you start by defining those two for us?
Sure. So a condominium is what we call a type of vertical and horizontal ownership. In essence, when you buy something that's not a condominium, you own from as far down as you can dig up into the heavens. There's no limit on the vertical boundaries of which you own. With a condominium, there is. You own not only a particular rectangle, typically, that you live in, but that has not only horizontal or perimeter boundaries, but it also has typically a lower elevation and an upper elevation. And so you have more of a cube than a kind of unlimited vertical rectangle. They're formed differently under the law. There's a whole process that needs to be undertaken. There's an approval process by the state for the majority of condominiums, which doesn't necessarily transfer on over to homeowners associations. The biggest defining difference between the two is the limits on your upper and lower boundaries of your unit, but there's many, many other differences that I won't bore you with today, but would be happy to on a later conversation.
Excellent definition, Mike. Thank you. Go ahead.
Thank you. So for condominiums, they have particular requirements under the law. A seller typically complies with some of these requirements by including a condominium disclosure addendum in their contract. That condo disclosure addendum does several things. It obligates the seller to disclose the amount of both special and regular assessments. Regular assessments are the ones that you expect to receive either monthly or quarterly or more rarely annually from the association. And special assessments are any assessments which are typically larger for a particular project that the association otherwise didn't reserve for. So for instance, if a storm comes through and there's damage that's not covered by insurance, the condo association may do a special assessment to raise money to pay for that. So the condo disclosure discloses any regular or special assessments. And most importantly, this condo disclosure document also requires a seller, upon the buyer's request, to provide 5 different documents. Those documents are the Declaration of Condominium, the Articles of Incorporation for the association, the bylaws for the association, the budgetary information, and the frequently asked questions for the association. Each of those has really important information, and I'll get into those in more detail. But the first thing a buyer wants to do is make sure the condo disclosure is attached, they requested the copies of those documents, and that they get those. That's something that's very important and a good agent can really help on. Now this affects not only buyers, but also sellers. Sellers will want to make sure that they have all of these documents together pretty close to the beginning of a listing, so that when they get a buyer, they're not running around trying to meet their disclosure requirements as soon as they're obligated to provide the documents. They want to have those things ahead of time to the extent possible. One kind of interesting thing which comes up quite often on this seller's condo disclosure is what's obligated to be disclosed for what's called pending special assessments. In the condo disclosure, a pending special assessment includes any assessment which has been discussed by the association and reported on the minutes of the association in the last 12 months. So that's not what you and I would normally think as of a pending special assessment. We'd think of one that maybe they passed last week but isn't due and payable yet. The reason this definition is important is if a seller fails to disclose a pending special assessment, one that's been even discussed in the last 12 months, they're liable for it. Now, most of the time, sellers don't know. They haven't gone back and attended the last 12 meetings. They don't know what's been reported on the minutes. And this is, again, another place where a good agent can come in and help. If they're familiar with the neighborhood, they may already know of pending special assessments. If not, that good agent will go to the association and ask for the last 12 months of minutes so that they can take a look at it. Now, it's really a seller's obligation. It's not a listing agent's responsibility, but this is a way that a good agent can help a seller meet their disclosure requirements and avoid those unknown expenses for pending special assessments that they didn't know about. If I haven't put you to sleep too much, I'll dive into the 5 different versions, 5 different types of documents that the seller's obligated to provide upon the buyer's request in the addendum. Any questions on the first stuff?
You're doing a good job. Let me just elaborate a little bit. We've done some videos where I've talked about the Walmart or the Ritz-Carlton kind of agent. And again, I have respect for both of those retailers. I'm in those kind of facilities on a regular basis, more so Walmart, obviously, but I buy different products from each. If you're working with a listing agent that's high touch, high service, and not just interested in mega numbers, if you would, that's another example of the kind of service. Your agent, because the seller doesn't know these things, your agent should be proactively going to the board, going to the office, alerting you, but going and gathering this information to protect your liability. Would you agree, Mike?
I would. And there's so many things that FSBO sellers and FSBO buyers don't know what they don't know. This is a perfect example, and time again, we find sellers failing to disclose things they don't know about, then they inadvertently become liable for them. Oftentimes to their extreme dismay. These things are usually very high dollar items, you would imagine, being special assessments, things that aren't disclosed. So I couldn't agree more that a good agent who knows what they're doing can pay for themselves over and over again.
Another technique we use, so let me ask a question and then make a comment. When a transaction is executed on a condominium, and how long does the buyer have to review the documents and approve of them?
So there's two check boxes on the condominium disclosure addendum. One says, hey, I've already gotten all that stuff ahead of time, the 5 different documents, and I don't need a right of rescission. If that box is checked, there's no time frame to review these documents. If instead the other box is checked, you have a 3-day right of rescission, which is relatively short given the quantity of information that's being given. It's one of the reasons we generally recommend an as-is contract, which has a 15-day right of inspection by default and a right to cancel. And it gives you some more time to look through the condo documents and then have that 15-day time period to cancel. So if there's something in there you don't like, you kind of have a backdoor way to a longer than 3-day period.
So when we represent a seller to start that clock, we immediately provide the documents. When I'm working for the buyer, I kind of forget about them because I don't want that clock to start any sooner than I have to. So it really depends on what side of the transaction you're on, what's in the best interest of our client. Again, when I'm working with a seller, we want that clock, we want it going immediately. But on the buy side, I want to give my buyer as much time as possible. So we don't, generally though, the sellers are going to provide it quickly, but we don't proactively go after that because it's all about what's in the best interest of the type of client we're representing at that time.
Absolutely. Delving into the different documents that'll be provided, and these are really good to read through if you have trouble sleeping. You'll be out in minutes.
Been there, done that.
The first of the documents that's provided is the Declaration of Condominium. This document is the basis of the condominium, describes the parametrical boundaries of each unit in the condominium development. It has use restrictions, no loud parties on Tuesday nights, that sort of thing. And two things which particularly come up and tend to be issues are restrictions regarding leasing and restrictions regarding pets. So we strongly urge any buyer to read through the entire declaration. If they don't take my advice and they only read a portion of it, read the use portion of it. That's really going to affect the day-to-day use of it. And if you are expecting to rent your unit, you want to make sure that you can rent it for the time periods and as often as you anticipated. That's often a surprise to many buyers who don't otherwise take a look at the declaration. There's the Articles of Incorporation of the association, which is a legal document which form the association. It's good to read through. There's not a whole lot in the articles which generally affects or interferes with closing. There's the bylaws and the rules of the association. And these are some additional restrictions that both govern how the condominium association corporation runs and some lesser important rules. So your main use restrictions, leasing, pets, that sort of thing, are generally in your declaration of condominium. You have a smaller set of rules in your rules and regulations for the condominium, which generally the board has the discretion to modify, are usually things like whether you can, the hours you can park and visitor parking, how many guests you can have over for a period of time, how long the pool's open, those sort of kind of minor restrictions. So those are in the rules and regulations, separate document from the Declaration of Condominium. There's also the most recent year-end financial information, which is very important and I'll come back to in a moment. And there is, because our state knows that people generally aren't going to read all of this, the state has mandated that each condo association create a list of frequently asked questions. And that list of frequently asked questions is obligated per the Florida Administrative Code to be updated each year by the condo associations. And it's meant to answer a lot of the questions a normal buyer would have as to, for instance, what their voting rights are, restrictions on use, leasing rules, the amount of any dues, whether or not the association's involved in any lawsuits. And of course, you want to take a look at the declaration and the rules for the actual meat and bones and the rule in detail, but you can generally find a summary of those rules in the frequently asked questions. Circling back, if I haven't put you to sleep yet, the most recent financial information for the condo association is a very important set of documents to look at. It will allow you to know whether or not the association is fully funding for reserves, partially funding for reserves, and there should also be what's called a reserve study in the documents. And this is really pretty neat. The reserve study tells you, for instance, that the roof has a 20-year life. You're 10 years into the 20-year life, and so you have an estimated 10 years left. It then says, here's the estimated replacement cost. Let's say it's $1 million. And so you would expect in that case for the association to have $500,000 reserved, half the cost of the roof repair, since half its life is left. So if you look at that and you see only, let's say, $250,000, then you should expect that when that roof reaches the end of its useful life, that there'll be a special assessment for that. And this is very helpful if you look at the reserve study and you find that several large improvements are coming towards the end of their useful life, and there's not enough reserves planned for those items, or already there's not enough reserves in the kitty for those items, then you should expect special assessments. It's not an absolute predictor. Things always happen that you don't expect, but it at least gives you a good idea for what the association plans on having enough money for, or more importantly, not having enough money for. And so those are really the important things to look at with condos. Almost all of these things carry over to HOAs other than the law that's applicable to them. In Florida, we have all these great disclosure requirements for condos, all these different documents we need, things we should look at. For homeowners associations, we're entitled to a one-page summary. And all that gives us is a document that says, yeah, there's some recorded restrictions out there. Here's how much we think your special assessments are, but not a whole lot of additional information. No requirements for the declaration of restrictions, no requirements for budgets. So those are things that you have to specifically ask for or obtain on your own, or include in your contract as things that you would want the seller to provide, but aren't otherwise by default obligations of the seller to provide. But all of the same considerations apply. You'll want to look at the budget for the association. You'll want to look at leasing restrictions, pet restrictions, and so forth. And that is kind of HOAs and condos in a nutshell. Of course, we didn't cover everything to do with them. These are kind of the highs and lows that a buyer or seller should be aware of and make sure they comply with.
So each and every week, we're addressing topics that really are meant to show how complex a purchase and a sale process is. Would you agree, Michael?
I would. My aim in this is to look at the various things that have been issues over the years and things that could have been avoided through better disclosure or more knowledge, and to address those issues so they don't repeat themselves.
So it's important when someone is contemplating a purchase or a sale, make sure that the real estate agent or broker that you've selected as your partner is well versed in this kind of information. They're proactive. We share this because it takes a lot of time to stay up with the latest laws. It takes a lot of time to do the right things. Again, that's the what I call the Ritz-Carlton Neiman Marcus approach, not the Walmart approach. Again, all three are great, great storefronts, great retailers, but we do different things at different stores. So by bringing Michael in here, and Michael will be back next week with us on Wednesday, back to the normal title time with Mike and Mike. It's all about providing you with the information to make the process easier. Reach out. Our contact information is up there. Michael's phone number along with mine is on the screen. Let us know how we can help. Don't hesitate for legal and technical questions. Address them to Michael from the real estate process perspective and how they impact you. I'd be happy to reach out and work with you on that. But we're here for you. Let us know how we can continue to help. Michael, again, thank you. I really appreciate this.
Thanks so much for having me. Look forward to next week.
All right, sounds good. Take care now.
Thanks, Mike.
Thanks.